Hi everyone, my name is Erin Gleason Alvarez, and your host for today's program on dispute resolution clauses that make sense. So quickly, by way of background, I am an arbitrator and a mediator. But before my neutral days, I worked as a litigator and as in-house counsel. And so I've lived on all sides of disputes, and this really informs the way that I think about dispute resolution clauses. A dispute resolution clause is something that no one really wants to use, right? But if the need arises, you want that language to make sense. Now, I have seen plenty of clauses that were probably drafted with the best of intentions, but in the end could not be acted upon in a reality that any of us live in. So, the purpose of my presentation today is to provide you with the basics of dispute resolution clause drafting, along with some ideas for tailoring the process to suit the needs of a particular agreement and the parties to that agreement. Our objectives for today are the following. So first, to understand the differences amongst mediation, arbitration, and other ADR tools, along with considerations for when each is appropriate. We'll also get the chance to appreciate the options that are available to parties in drafting dispute resolution clauses, and then review some cutting-edge approaches to dispute resolution that address parties' common reservations when it comes to particularly arbitration. Lastly, we'll consider expectations for mediator and arbitrator qualifications. Now, I included this last point because I think it's crucial to choose the right supports for the clause that you've crafted. Parties often complain that arbitration, for example, takes too long and costs too much money, or that mediators act more like carrier pigeons than skilled negotiators. So these issues can often be pretty easily addressed when counsel makes better and more informed choices in how the dispute resolution clause is crafted, and then who's selected to act on that clause. Let's start with a review of the different dispute resolution tools that are available to you. So we'll briefly review the respective pros and cons amongst negotiation, mediation, and arbitration, along with some considerations for when each of these is appropriate. When considering dispute resolution tools, I think of it on the spectrum, with litigation on one side and then negotiation on the other. So while litigation is bound by rules and often engenders a more combative environment, negotiation is at the opposite end, right? So there aren't really any rules to follow. And from my perspective, it simply works best when it's more of a collaborative nature. Mediation that can be combined with arbitration, and arbitration ultimately fall within these two pillars. So as we move from left to the right, from mediation and on over towards arbitration, the tools here get progressively less collaborative, generally speaking, and more bound by formality. Now, thinking of your options in this way can help to sort out the goals that you have for a dispute resolution process. Based on the type of dispute and the people involved, what do you need from ADR? Formal rules and structure, or collaboration and creativity? On the collaborative side, negotiation is something we all do every day, whether at work or at home. Now, I don't think there's any art or science involved in this. It's really a way of communicating, and you likely have your own style and approach to these conversations already. Of all the dispute resolution mechanisms available to you, this one's probably the most accessible, the most efficient, and it has the potential to offer the most cost savings, certainly. Negotiation can occur in the traditional sense, person-to-person discussions, and it can happen with or without the assistance of counsel. The benefits of relying on negotiation are many, and perhaps a longer list than we have time to cover today. For now, the ability to identify a negotiation strategy and implement it early in the life of a dispute by involving as few people as possible perhaps provides the greatest opportunity for cost control and efficiency on the dispute resolution spectrum. It also offers its constituents with the added bonus of crafting your own solution, right? There are no hard and fast rules here for what needs to happen, which can allow for all of the negotiators involved to feel more bought in or vested in the solution. And then lastly, it's most likely a confidential discussion, right? Which may be a particularly important factor for the parties as well.